I now invite the Honorable Sheikh Imam.
Thank you, Honorable Speaker. Let me start off by saying that in terms of the recommendations that was put forward in respect of the removal of Advocate Mkhwebane from the Office of the Public Protector, the committee deliberated on this matter. Millions of rands have been spent, waste of taxpayers' money. If you see what the current Minister of Finance says, the financial situation we find ourselves in this country, but just look at the amount of money that has been wasted on this matter. Now, very importantly, Honorable Speaker, I find a level of hypocrisy in this House, and let me tell you why I say that. The Constitutional Court upheld a Pretoria High Court ruling that found that Mkhwebane was dishonest in an investigation. Who appointed those judges? This House. The Public Protector lost an application for leave to appeal an order by the High Court in February 2018. Who appointed those judges? This House. A full bench of the High Court set aside a controversial report and its remedial action, which ordered the SIU to recover more than 1 billion rand from ABSA. Who appointed those judges? This very House.
Honorable Sheikh Imam, I'm really sorry. Please take a seat.
Take a seat.
What is your point of order, Honorable Member?
The point of order is that Parliament does not appoint judges. The Speaker on the podium is misleading the House. I'm calling a point of order on that one. He must stick to his speech. He must not mislead this House.
Thank you very much. Honorable Kalipi, take your seat. You may proceed, Honorable Member.
Thank you very much. Recommendations do come to this House, does come through to the committees, okay? But no one in this particular House has ever rejected. Nobody in this House have ever rejected or raised concerns about any of the judges, even when they were appointed by the judge president in this country.
Honorable Sheikh Imam, I'm really sorry. Take your seat. Honorable Shivambu.
Not when a member stands up here and says that we are responsible for the appointment of judges, it's misleading the House and it's misleading all of us. And it's purposeful. We understand the limitations of the NFP and that they're not coming back next year, but don't mislead us. We are not responsible for appointment of judges. It's done elsewhere, it's not us. And to repeat that as if it's a factual basis, it's misleading, and we must not allow that to just pass. It's not a point of debate, it's a factual issue. We are not responsible as members of Parliament for the appointment of judges. And the member must withdraw that particular nonsensical insinuation. It's as simple as that.
You've made your point. Order. Honorable Shivambu, you are partly correct. But if I may also correct you, members of Parliament, Parliament is represented. It just holds. Parliament is part of the processes of appointing judges. So can we leave it at that? There's no need for us to debate on the matter. Thank you very much, honorable members. Proceed, honorable member.
I think Honorable Shivambu should attend to the crisis in his political party, firing 200 some odd members, asking his members to be corrupt in going to fine 1.5 million rand for transport. Let me also say to all these other EFF members, don't you worry, you'll be next, and you'll be next, and you'll be next, and you'll be next. All of you soon. Now, Honorable Shivambu is very selective in his hearing because he did not hear what I said in the end, that I also said that nobody in this house ever rejected any judge or anyone or commented or raised concerns about anyone that were appointed. And we talk about the separation of powers. The judiciary has a responsibility to deal with these matters. Now, judge after judge after judge has found the public protector
Order,
wanting
honorable
and
members.
failing to carry out their
Order,
responsibility.
honorable members, order, honorable Sheikh Imam. Fortunately, your time is up. Thank you.
The NFP will support the report tabled here today. Thank you very much.
Thank you very much, honorable member. I now invite the honorable Tlape.
Ke a leboga Musa Kgotla, Deputy President, members of executive, honorable members. Honorable Speaker, we must acknowledge that this committee drew so much attention locally and internationally as a pioneer, a multi-party committee, obviously with differing views, coupled with many theories around its mandate. Let me also attest that this was a committee of parliament. And interestingly, as members, we agreed on the basic principles or guidelines that would have navigated us through uncharted waters. According to Katifi report from the Institute of Principal Studies, principles set the foundation. They recognize what is true in new or unknown situations. So principles, in a way, helped us as a committee to interpret and apply the truth to the evidence we received, hence the outcome today. So as the committee, we became principled and chose gore, ga re kitla re seka motho, re ya go seka molato. Ra ba ra tsaya kgakollo go tswa mo go Davis Thorio, ha na re go botlhokwa gore o lebileng. Se se botlhokwa ke se o se bonang. It's not what you look at that matters, it is what you see. So some of the wrongs we saw when we looked at the PPSA and the evidence that was put before us are the following. Weaponized and misuse of disciplinary policy to instill fear, intimidate and victimize some employees, whereas the policy requires that disciplinary measures be fair, not punitive, and be used as a corrective measure. Cohesion of employees to set unreasonable and unrealistic deadlines for reports without considering human and financial challenges of the office and the complexity of matters. This resulted in employees rushing to complete investigations to maliciously comply because they feared Audi letters and subsequent disciplinary actions that often followed. Executive managers who served the office under a number of public protectors demonstrated how this destroyed the internal capacity of the office and how it led to low staff morale and unhealthy work environment characterized by fear. We heard how the PP sought to eliminate anyone who dared to differ with her. Diversion of financial resources meant for outreach programs to improve accessibility of PPSA and enable investigators to do physical inspections. Investigators were left only with being able to conduct desktop investigations, thereby impacting on effectiveness and litigations due to poorly conducted cases. This resulted, honorable members, also in a high turnover of skilled and competent investigators and a weak institution that could not deliver quality work as expected. There was bypass of quality assurance mechanisms during the investigations of some of the charges that were served before us, such as CR17 and the SARS unit matters, with investigation being kept closely to the PP and certain individuals, deliberately ignoring certain evidence presented to her without explanations, as well as deliberate misuse or misleading of the wrong executive ethics code. And still, as the committee, we remain principled that we will not judge the person, but will look at the wrongs that were done. Demonstrable limitations on understanding the powers she possesses, lack of knowledge on some aspects and application of the law, and making far-reaching findings like that of the total implementation of the Inspector General of Intelligence report when she was advised that the SSA could not authenticate the report, nor did the IGI have jurisdiction or to investigate SARS in terms of the National Intelligence Act. These, honorable members, are few examples of many instances of incompetence and misconduct that characterize the tenure of Advocate Mkhwebane le fa gona re ne re sa seke motho re seka molato. As the committee, we cannot turn a blind eye to the devastating impact this has had on the office and the public perception about the institution that is meant to strengthen our constitutional democracy, lest we fail on our mandate, that of probing her fitness to hold office. Ka jalo Musa Khotla re le mokgatlo wa African National Congress re dumelana le tshwetso ya gore mosireletsi wa setšhaba a tlosiwe mo maemong a gagwe jaaka fa bopaki jotlhe jo re bo reboletsweng ra bo ra bo sekaseka bo supile fa sa itekanela go tswella ka tiro e lebaka legolo go gore ga ra seka motho re sekile molato ke a leboga.
Thank you, Honorable Sape. I now invite the Honorable Member S.M. Jafta.
Thank you, Honorable Speaker. We must place it on record that our position on this report must not be confused. We hold a strong view that the flag bearers of our Chapter 9 institutions are not beyond reproach. We have full confidence in the judiciary, particularly the Constitutional Court and all other courts, including KZN High Court Division. We believe that the office of the Speaker has been impartial in its dealing with Section 194 committee. We place all this on record to underscore the following. While we agreed that this process was above board and that the courts and the office of the Speaker have been fair throughout the process, we believe that this report must be viewed by members from an Ubuntu standpoint. We do not carry any brief for Advocate Mkhwebane. Her term will expire in October. Impeaching her just a month before it expires would be in line with the principle of Ubuntu, which has since been accepted as one of the values of the Constitution. The Constitutional Court's judgment in Magwenyana, for example, reminded us of the basic underpinning of Ubuntu as entailing a balancing of the interests of society against those of the individual, for the maintenance of law and order, but not for dehumanizing and degrading the individual. The Constitutional Court went on to rule that Ubuntu translates as humanness. It expresses itself in umtu ngumtu ngabantu. In Furman versus Georgia, the Supreme Court of Appeal of that country pronounced that the measure of the country's greatness is its ability to retain compassion in time of crisis. The Holy Quran tells us that Ubuntu or Azabia embodies compassion and unity. Honorable Speaker, Steve Biko affinities to Ubuntu was premised on the recognition that we needed to place less emphasis on power and more on humanity. Rev. Martin Luther King reminded us in 1965 that all humanity is tied together. The Holy Bible speaks about holiness and forgiveness. The late Archbishop Tutu told us that in Africa we have something called Ubuntu in Nguni languages or Butu in Sotho, which is difficult to translate into English. It speaks about holiness, it speaks about compassion. The AIC will accordingly not vote in favor of this report. Thank you.